Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On April 18th, 2025, in one of the longer orders on the multiple motions in Limine, Judge Hippler entered an order on state's motion in Limine regarding neuropsychological and psychiatric evidence. This has to do with Judge Hippler's ruling on the state's motion addressing Mr. Kohberger's recent diagnosis of autism spectrum disorder. When you have a long order like this is 11 pages, it's sometimes helpful to go to the very end and find out what the ruling is and then work your way backwards. So what the court's saying here, page 11, section 5, order based on the foregoing, the state's motion in Limine regarding neuropsychological and psychiatric evidence is granted in part and reserved in part. This is a little unusual. This means that not 100% of this motion is being granted. The other part of it is not being granted at this time. If the court needs to go back later and this becomes an issue later in the case, he will then take it up and then either grant it or deny it. So this is only in part granted. Let's see if we can figure out what's going on here. We're going to go back to page 1. It says here, the state seeks to prohibit defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations performed by his disclosed experts, Dr. Rachel Orr and Dr. Eileen Ryan. There's a footnote here. Specifically, the state objects to the testimony proposed in Dr. Orr's and Dr. Ryan's respective experts' disclosures, which includes their reports. I want to point out here, this is stating during the penalty phase. This is if and only if there's a conviction, then matters would move into the penalty phase of the trial where the issue of sentencing would then be determined. Going back to the body of the order, paragraph 1. State argues the proposed testimony falls outside the mental condition evidence allowed by IC 18-207. That is a statute, ladies and gentlemen. Defendant responds that he is not relying on the proposed testimony as a mental element defense under IC 18-207, noting his relevant diagnoses or physical conditions, not mental conditions. Rather, he tends to present the evidence to aid the jury in understanding both the physical implications of his diagnosis and contextualizing his allegedly unconventional courtroom demeanor. Next paragraph. Oral argument on the motion was held April 9th, after which the court took the matter under advisement. And now, having taken the matter under advisement, here's the ruling. It says, the court finds that if defendant does not testify evidence of his diagnoses to explain his courtroom demeanor, which is described here by defense as allegedly unconventional, well, that's not relevant if he doesn't testify, says Judge Hippler, and or is inadmissible under IRE 403. Ruling is reserved as to certain behaviors that may become relevant in rebuttal, except for expert testimony that he was physically unable to commit the crimes for which there is no disclosed opinion. Now, we as the public are a little bit at a disadvantage here because most of the expert opinions are under seal. But Judge Hippler, who has seen all of the expert opinions, is telling us here that there is no expert opinion that's been disclosed that says that Mr. Kohberger was physically unable to commit the crimes. So basically, everything that we need to know is in the second paragraph of the first page regarding what was granted, what's reserved for later. If you'd like to review this order, please go to the Idaho Cases of Judicial Interest, plug it in any search engine of your choice. It will pull up the cases high profile in Idaho, Kohberger case being one. Go to April 18th and you can read this 11-page order in its entirety. Thank you for joining us here today.